we'll get started. So look, what I've got for the group tonight is essentially a what I would call HR and workplace relations update. So on-demand HR, we're in the workplace relations space. It's a bit of a niche space where we sort of operate between, I guess, your employment lawyers and I guess you could say your HR consultants, and we are very much focused on the law side of HR. We operate as a paid agent in the Fair Work Commission. I've personally represented clients in about 150 cases since 2010 as a paid agent. I've run everything from conciliations to evidence preparation to hearings. So we have a very unique understanding from a consulting perspective on HR and workplace relations matters that most other HR consulting organisations or workplace relations consultants wouldn't have the same kind of experiences that we've had. A lot of others do operate on that kind of theory of, well, this is what I've been told by lawyers, or this is what I've been, this is how I understand it works, but without actually any real tribunal experience. I'll get started with tonight's presentation, and as I said, feel free to come in at every time, and basically we'll answer any questions as we go along. So let's start with a bit of a look at some of the key developments in the past, particularly in the last 12 months, let's say since the start of COVID. So we've seen, challenges in two key areas of workplace relations. We've seen legislative challenges and new things that businesses are being expected to comply with, along with external challenges such as things like COVID-19, floods, things like vaccinations, things like the end of JobKeeper, obviously, which just recently finished for some businesses, and all of that coupling with all of that combined, creating an environment where businesses have been constantly looking at restructuring and the possibility of redundancy. So I really want to talk about tonight both of those key things, so the legislative challenges and the external challenges that a number of small to medium businesses are facing in their day-to-day operations and their day-to-day dealings with their employees. So before I get into that though, I wanted to kind of give everyone, again, for those who may not have a great deal of knowledge on these particular subject areas, I wanted to kind of just get back to some very basics of how employment standards generally work and what is the basis for employees and their employment conditions. So I guess I'd like you to look at the pyramid that I've created on the right, and the pyramid really explains the kind of hierarchy of employment conditions and how things generally work with employer and employee arrangements. So at the very, very core of our national workplace relations system is what we call the National Employment Standards. So that is the 10 simple national employment standards, which I won't go through them, but is basically available to all full-time and part-time employees. There is certain parts of the National Employment Standards that are not available to casuals, but certainly for full-time and part-time employees, the National Employment Standards apply to all of those permanent employees. So sitting above that, so let's assume that we have an employee who's award-free, which, believe it or not, is not actually that common. A lot of people think that their employees are award-free, and they're not actually award-free. Most award-free occupations are occupations that are generally very, very senior management, that fall above the scope of any potential industry or occupational award. So, but let's assume for the purposes of this first layer of the pyramid, a person's award-free, they would be entitled to, at the very least, the standards that are in the National Employment Standards. We then go a level above that, and we look at what are our enterprise agreements. So these are agreements that are collectively reached between an employer and either the whole workforce or a group of its employees on the terms and conditions of employment. Now, in most small to medium businesses, enterprise agreements are not that common. They're probably more common in your larger businesses. They're more common in your construction fields, typically, where they're trying to get enterprise agreements in place to avoid disruption from the union, or because the principal contractor has been put under pressure to have only EBA-based contractors to do particular types of work. So Think of the enterprise agreements as kind of the second layer of the pyramid, although in many cases, organisations may not even have an enterprise agreement. In most cases, they in fact won't. So enterprise agreements will apply to some, but not most businesses. We look at the third layer of the pyramid, and the third layer of the pyramid is the modern awards. So this is the 120 something modern awards. I don't know the exact count as we speak, but these modern awards cover essentially industries and occupations, various different industries and occupations, and set the terms and conditions of employment for that particular industry. So think of modern awards as being things that are in addition to the national employment standards in the situation where no EBA is in place. So you typically will be relying on one or the other. You'll be relying on either an enterprise agreement in that workplace, or you'll be relying on the modern award. So one layer of the pyramid will not exist for a particular type of employee. Then sitting above your modern awards, you then have your employment contracts essentially. So there is, and what we'll get into in tonight's presentation is that there is various ways that employment contracts need to be considered and constructed. What we see far too often is situations where, and quite funny, we even see lawyers producing content for their clients, which is kind of one size fits all employment contracts, which do not take into account at all the modern award that applies, the rules for annualised salary arrangements under that modern award, and the various other obligations that may exist in that modern award. And we'll talk about what some of those obligations are tonight, and why and how we look at that in the context of a workplace relations review. So I guess at a high level for tonight, what I'd like to cover is the legislative challenges, the external challenges, and then really talk about how that fits in the layers of the pyramid that we refer to there as a very foundation for workplace relations, the system that we have in Australia. So on to our next slide, which really covers recent changes around the definition of casual employment. I'll start with this notion of casual employment. So this is actually a very recent change to the Fair Work Act, and this was something that was part of the recent reforms that largely being driven by the Minister, Christian Porter. And what the whole design of these reforms is geared at doing is removing some of the uncertainty from casual employment that we've seen in some of the recent decisions with WorkPack and Skeen and Rosado and Skeen. So, Rosado and WorkPack, should I say. So what we've got here now is a definition of a casual employee is based now on the original offer made to the employee without taking into account any subsequent conduct of the parties. So in the past, what the Commission would kind of look at and what these cases looked at was the conduct of the parties. What the new reforms essentially say is that now, so long as there's a very clear intent contractually on what the employment is intended to be, then that is given to be casual employment. And look, there are still other obligations that do apply. There is an obligation to offer casual conversion to a casual employee after 12 months, and there is the residual right for them to request that casual conversion. But that doesn't change the fact that they are, for all intents and purposes, a casual employee until such times that either a conversion is enacted or and in most cases, a conversion is not even sought by the employee, and I'll get into some of the reasons why that's the case. But ultimately, the biggest shift is around the on-paper relationship between the parties as trumping the what's happening in practice relationship between the parties. So that's a significant change. And again, we'll talk a little bit later about how businesses can now start to think about that in the context of their workplace relations affairs, particularly when they're employing a lot of casuals. So the other thing that the reforms now crystallise is the requirement for businesses to issue what is called a casual employment information sheet. And for those who are familiar with the Fair Work Information Statement, it will be a similar looking document to that will go to the rights of casual employees in these circumstances. So obviously, if there's a casual employment information sheet, the casuals will be required to receive this, which will probably talk about things like casual conversion and so on and so forth. The other thing that these new reforms deal with is they deal with the ability to make orders relating to casual loading amounts if the employee is found not to be a casual employee. So for those who followed the Skeen and Workpack and the Wazardo and Workpack cases, one of the biggest criticisms of those cases was that these employees were effectively allowed to double dip. They received their casual loadings during their employment, and the court didn't make any requirement for them to offset those loadings against the annual leave that they were eventually paid. Now, look, I wouldn't be losing too much sleep over those two particular cases because they were a very, very unique set of circumstances. But what the reforms now do is that if there's any doubt about the employment, it allows for the ability for there to be orders for casual loadings to offset, when there's a situation where the employment is found to be permanent. And really that should only happen now if the contractual documents are bad. Because if you put together decent contractual documents now that deal with the new requirements in the reforms, you should be very comfortably be able to establish with confidence casual employment. So I hope that kind of gives you a little bit of an overview, and just flowing on from that in terms of what we mean by a firm and advanced commitment. So essentially the employer, the whole notion is now that there's no firm advanced commitment to ongoing work. And the four factors that really are looked at is that whether the employer can elect to offer work and whether the person can elect to accept or reject work. So again, the first thing that should be clear to all casual employees from here on in is that they can accept or reject work. If they can't accept or reject work, well, it's not really casual employment. Whether the person will work only is required is another consideration. Whether the employment is described as casual employment, we covered that in the last slide, and whether the person will be entitled to a casual loading or specific rate for casuals under the terms of the offer or Fair Work instrument. So again, making it clear that there's a casual loading as part of a casual employment arrangement would go quite far in establishing that clearly there's a casual employment arrangement on foot, and that is the basis upon which the parties have decided to enter into the engagement. So that is the real change around the Fair Work Act, what we can expect to see going forward. And it does provide some certainty, particularly in a number of industries, certainly the mining industry, which is where this whole thing started around Workpack and Skeen, and Wazardo and Skeen, but also in many other industries where there's been a possible concern about a knock-on effect. So so I hope that gives a bit of an overview as to casual employment. I want to talk about real impacts and some final recommendations on that particular part of the subject. So first of all, I think it's important to know for people who are worried about conversion obligations already existed under most modern awards as either being the ability for casuals to convert after 6 months or after 12 months. Now, look, most casuals don't choose to convert anyway. And the reason they don't choose to convert is, and obviously I appreciate that probably people around the room enjoy your maths. If you do the numbers, 25% loading doesn't equal the costs of the leave. So 25% loading is often higher than the cost of the leave, and people think of this as real, what's going in my take-home pay effect. And when they look at, okay, I can lose 25% of my pay, go on to permanent employment, and I can get the benefits of leave, they will most often look at it and weigh it up and go, no thanks, I'll stay as a casual employee, I'm still getting regular and systematic work, I'm not worried about job security. And this is another, thing we hear in the political debate about, well, there's all this job insecurity and that, employers are abusing it, all that sort of stuff. I mean, there's so much. There is the competitiveness in the labour market right now is as competitive as it's ever been, and even with COVID impacting on some industries, the majority of industries are humming along beautifully at the moment, and we are seeing across the wide range of clients that we're dealing with, competition for people in various areas is still at really very close to all-time highs. So again, casuals are quite comfortable with their 25% loadings. They're comfortable with their so-called insecure employment, and not a lot of them are seeking to convert. In fact, in the last 11 years of me consulting to the best part of 450 clients, I think we've dealt with conversion about 3 times. So it just shows you how rare it is that those things will actually be taken up by casuals, and really these reforms don't really change any of that. So that is, I guess, some of the real impacts of this and how much this actually plays out in practice. I think the three recommendations I'm going to make to all of you, either in your own practices or with your clients, is to clearly have casual conversion clauses in your employment contracts, because that will ultimately make it clear that they have the obligation to convert, or have not the obligation, they have the right to convert, and ultimately, if they decide not to exercise that, that's a matter for them. And it's a good way of also notifying them up front that they have that right at a future time. The second thing is that ultimately clearly identifying the nature of the employment in the contracts as being casual employment. So that's important for the purposes of meeting the definitions that we spoke about in the previous slide. And the other thing is clearly identifying the casual loadings in those contracts and in those pay slips. So again, if you've got a casual employee who's paid $30 an hour and it's $24 an hour plus a 25% casual loading, the recommendation is that we split those for the purposes of payroll and for the purposes of pay slips, because that clearly shows a pattern that casual employment has been exactly that, and that there's been a loading as part of that casual employment arrangement. Where there can be sticky situations for employers is when it just simply says there's $30 an hour, there's no clear reference to casual employment, and then there's ambiguity about, well, was the employment part-time, was it casual, where's the leave accruals, those sorts of situations. So I hope that kind of makes sense on the whole notion of casual employment. All right, well, I'll move on then to the annualised wage arrangements. So let me just click ahead to the next slide. So this is another obligation that came into play in early 2020, in March 2020, as part of changes to the modern awards. So it doesn't exist in all awards, but it does exist in 22 of the modern awards. And those modern awards have particularly wide coverage, and we'll talk about which ones they are in particular. But what these annualised wage arrangements, or annualised salary arrangements clauses in the modern award do is they affect the full-time employees who are paid an annual wage or an annual salary under one of the impacted awards. And depending upon the award, the annualised wage arrangement can include things such as minimum wages, allowances, overtime, penalty rates, and leave loading, the typical types of things that you see rolled up into salary arrangements. So these provisions do capture a lot of salary arrangements, and we'll get onto what some of those obligations might be. So the first thing that the employer needs to do is ensure that the employee's annual wage is high enough to cover the award entitlements that they've included in the arrangement. Obviously, it can't be less than what they would have earned over the year or over the period of time. But the award goes further than that and talks about which classifications in some cases can be paid an annual wage, what entitlements can be included in the annual wage, and whether they need to agree to the arrangement or whether it's a supplementary document to some sort of employment contract that may already exist. So as each award is different, it's important for you to understand what the annual wage arrangement clause in your award may be. And I'll go to exactly that right now. So I'm going to show the group the awards that are impacted by this annualised wage arrangement change. So you can see there a list of, I think it's 16 plus another 4 below, and there's a couple more to come. So we've got the Banking, Finance and Insurance Award, which covers a pretty wide range of employers and their employees. So those awards now have annualised wage or annualised salary arrangements. So if you've got people on salaries in that award, then there are additional obligations that apply. It's not simply good enough to just issue an employment agreement or a contract and say, that's okay, this has been written by a lawyer, we've met our requirements, and just ignore that the requirements under the award even exist. So Banking, Finance and Insurance Award is one that has very wide coverage and may, certainly there may be people in the room that have employees or, know of clients that have employees that deal with that. The Clerk's Award is probably the biggest one in terms of broad sweeping coverage of a wide range of administration and clerical employees. So what that requires, again, is a whole range of additional obligations on if you have a salary and the person is covered by the Clerk's Award, then these are the additional things that need to be done. We'll get into what exactly that is in the next slide. There's a few other awards there that, probably that nonetheless apply but have less of an impact. So you've got the Pharmacy Award, which covers a lot of pharmacies. You've got the Mining Award there, obviously covers quite a lot as well. You've got local government, you've got manufacturing, you've got telecommunications, and there's a number of others there. And we expect there's going to be further provisions and changes to two other key awards down the bottom, which in particular the Restaurant Award and the Hospitality Award, which have very broad sweeping coverage in the restaurant sector and obviously in the hospitality sector. So if you see one of those awards that applies to any of the businesses that you deal with directly or indirectly, it should be a red flag that there's something that needs to be looked at in respect to any annualised wage arrangements. So that's the awards that are covered. Into talking about, okay, well, what are the obligations? So the first and foremost, the first obligation is that there must be an agreement in writing which includes the annual wage paid, what award entitlements are included, but how the wage has been calculated and the outer limit of penalty hours within a pay period or roster cycle without extra payment. So the first part of that long sentence is, okay, we've seen that a lot before in contracts. It says what the salary covers and so on. So that part of it, is not that scary. The second part of it is the part that typically businesses haven't addressed, and that is how the wage or salary is being calculated. What is the outer limit of the penalty hours within a pay period or roster cycle without extra payment? So that includes things like overtime, Saturday penalties, and so on. And obviously that's going to be more of a problem the closer the salary is to the award levels, the less flexibility and room to move there is going to be in these types of annualised salary arrangements. The second obligation is, and look, this is an obligation that's always existed, it's just something that's reiterated in the annualised wage arrangements, is start and finishing times at any unpaid break. So any sensible employer would be recording those things purely and simply because if there's any dispute in the future, you have something to rely upon for the purposes of dealing with any underpayment claims or any unpaid overtime claims or whatever it may be. So that's the second obligation, but not a new obligation in this particular situation. The other thing that it does, the other slight change in the terminology around this thing is that it requires the employee to acknowledge the number of hours worked at the end of each pay period or roster cycle. So in practice, if an employee is submitting a timesheet, that would be good enough. If an employer is filling out a timesheet without an employee's kind of some sort of contribution or consent to that could be a potential problem area. There's numerous other ways of keeping time and wages records. It could be a Bundy card, it could be a finger scan, or it could be a timesheet. It could also be even just a log in and log off computer style situation, or a log in, log off alarm situation, or a system log in, log off. There's various different things over the years I've talked about with clients as to how you can log hours effectively. But and look, and every business wants to deal with these things different. Some don't want to have the notion of employees watching the clock, so to speak, and they culturally don't want to have that look and feel about it, while others are quite comfortable with pushing those things very firmly at their employees. So again, not a new obligation, but certainly there's more of an emphasis now on the employee acknowledging the hours that they worked in any given pay period. So basically, the other thing is that the reconciliation of employees' annual wages against award entitlements. So the key thing around that is that every 12 months after the agreement commences, when the arrangement ends or when the employment ends. So it's a little unclear in the modern awards as to how, I should say, a little unclear with the Fair Work Ombudsman as to how strictly they will enforce this 12-month reconciliation. So what you're supposed to do in these annualised wage situations is reconcile how much the employee has earned as their salary versus what they would have earned over 12 months if we followed the award conditions. So in that situation, what I would say is that where there's a situation where there's uncertainty around that or there's a shortfall, then there may be obligations to make additional payments in those circumstances. So, and again, that's going to happen in situations where the salary is going to be very borderline with the award levels. So, that is a bit about the obligations, and I just sort of want to round this particular point out with why is this significant. So why this is significant is the first 12 months reconciliation was March 2021. Now, look, we haven't really heard anything from FWO yet about what industries they might target, what awards they might target, bearing in mind there's only 22 of them. But we have heard from FWO that the priorities in 2021 will be underpayments of staff in the corporate sector, which could be admin, banking, finance, most definitely, have become a significant issue of public concern. And we see it, the large employers in the past 2 years that have had underpayment of wages. It's staggering. If these large businesses can't comply, well, how can small to mediums be expected to meet the requirements of our workplace relations system? So, nonetheless, the Fair Work Ombudsman, one after another, they seem determined to make a big name for themselves, and they seem determined to, get on the front of the media headlines by slapping down a penalty or a fine on some business or cracking down on some sort of underpayment. So, again, expect that there will be compliance enforced. We just don't know to what extent. Obviously, there was a crackdown in 1920 around wage theft. There was actually a serious case around maid establishment with significant penalties there, as you can see in the fourth dot point. There is most recently an increased compliance requirement for small to medium business around the penalties, and we'll get onto that in the next slides. And look, probably the main thing I would be saying to businesses out of this is just review your affairs, just review your workplace relations situation, understand what awards apply to the employees in my business or the employees in my client's business. If the client or if the business doesn't know those things clearly and has confidence in what those things are, then I'd suggest that it's probably time to address that particular issue, because a failure to address that could result in a whole bunch of unintended consequences, as we've kind of gone through in today's presentation. So that's a bit about the annual wage arrangements, annualised salary arrangements. I said, in essence, really, the annualised salary obligations, in the most part, will probably supplement your employment contract arrangements. So you can still have your existing employment contract arrangements, provided obviously they're not in breach of the award in terms of rates and so on. But the annualised wage arrangements, annualised salary arrangements create additional obligations that need to be considered and met. And look, I could talk all day about how those things can be met, but that can be very unique to each individual business and how they might best deal with those particular things. So I'll move on to mandatory classifications. This is another thing that we've seen in a number of awards in the past year, where there's now a requirement in some awards, not all awards, and this is why it's so important to know what award covers the organisation I'm dealing with, to notify employees in writing of their classification levels. And there can be two types of provisions here. There can be blanket-wide or award-wide requirements to have the classification level stipulated, or there could be this other box, which is it only applies to a particular type of employment. So yeah, and again, that varies from award to award. So to take Clerk's private sector award as an example, because that's a very wide coverage award, requires all employees to be advised of their classification level under the award, and then this kind of tears into the annualised, or ties into the annualised salary provisions of the award, making it very easy for the employee to compare their wage against the award minimums, and well, am I getting enough extra money in my salary for the overtime I'm being expected to work? So what you'll probably see in a lot of these awards, and probably more so as time goes on, is this linkage between classifications being required to be advised against the annualised salary arrangement that sits in that award as well. So to take a different example, the manufacturing award only requires mandatory classification for casuals. So that's where the award is right now. The tricky thing about these modern awards, and this is where it's very different from the system we had some 11 years ago or some 12 years ago now, is that these modern awards continue to kind of evolve and update and change. And look, even as a consulting business with 6 consultants, we find it difficult ourselves sometimes to keep on top of them. We try and just keep on top of the key things that need to be communicated out to clients, because sometimes you'll think you're across it and then there's a change and you try and act on those changes as quickly as you can. Look, FWO do a whole bunch of update services that we subscribe to, but at the end of the day, there's 120 odd awards. So, some awards will impact their clients more than others. Some will have very little impact. So, to be across all of them is often quite difficult. So, again, I think it's always good for a business at any given point in time to review their affairs and then look at reviewing their affairs again, periodically. So, the compliance consideration is very award specific in this regard, and it's always something we consider when we conduct our workplace relations reviews for either new or existing clients. So, important to understand. Just back on some of those penalties. So I'll move on to, I guess, compliance and penalties that we're now seeing as part of these changes. So the small business fines now for underpayments, and again, I'm not saying this. I'm not going to, come in here with a whole bunch of scare tactics and say that every business is going to be fined for an underpayment. The large majority of businesses I've dealt with in underpayments haven't been fined for them. So where there's been non-compliance, but sort of in good faith arrangements, then there might be some sort of requirements for underpayments to be addressed. But there has been a number of serious cases where there's been fines for underpayments, and those small business fines have now gone up from 66 to 99,000. So medium businesses, it's either 2 times the benefit obtained or 99,000, whichever is the higher. Large businesses, it can be 3 times the benefit obtained, or 666,000, whichever is the higher. A 50% increase in fines for sham contracting arrangements under the Fair Work Act. So that's I think it's 352 it might be, or something along those lines. And severe cases can attract up to 4 years jail time. So that's another change that they're sort of trying to push in this criminalising wage theft and things like that. Now, will we see someone do jail time? Probably eventually. There'll be someone in the corporate sector that will be jailed as a result of an underpayment. Will we see it all the time? Probably not. Will it be used as a scare tactic by lawyers to broker settlements on behalf of their individuals who are aggrieved about their underpayments? Probably. So all of those things are going to be in play in the time ahead. I'm not sure why these reforms make any sense, particularly when businesses are, you could say, there's not really a great deal of good reason for more regulation at this point, but it seems to me to be balanced off against perhaps some of the gains in casual employment and so on. So in any case, the 2 other things I wanted to quickly cover on this slide is that there has been some awards now that will have additional flexibilities for part-time employees, and the other thing that is available to part-time employees, or should I say to other employees in awards now, is the ability to change duties and the location of work. But again, most of those things are done by agreement anyway, so not significant other changes in that regard. And so the main thing to take out of this slide would probably be around the compliance issues. I'll move on to vaccinations. So I'm going into now kind of some of the external factors. So looking at, some of the things that your clients or your businesses might be confronted with this year. There's yet to be any precedent in the courts around this notion of vaccination for COVID-19 specifically. So it's going to be a very, very interesting space, and there will be cases on this year. I can almost guarantee it. There is some legal experts out there who suggest it may be fair and reasonable, and maybe some that even go further to suggest employers might have a positive obligation to protect employees and customers. But should a business go anything further than what the government requires them to do? Our position at the moment in advising our clients is no, that follow the government guidelines and probably no more than that at this point. Some may take a specific view that they want to take things further with that, but if you're taking things further with that, then that you may also carry some of the risk associated with vaccination. So you either carry risk associated with lack of vaccination, or carry risk associated with vaccination and possible adverse effects of that. So I think the sensible middle ground is to follow any industry requirements the governments in the state implement. So that would be my, I guess, an overarching principle on how businesses, I think, should think about this concept. There's a very interesting case actually last year. Is Arnold v. Good Start, and this case was actually not related to COVID vaccination, but was related to flu vaccination. And what this case went to was it went to a childcare worker who lodged an unfair dismissal claim for refusing to receive a flu vaccination, was ultimately dismissed from their employment. Now, the disappointing thing about this particular case is that the employee actually filed out of time. So you have 21 days to file. So ironically, despite the case, it would have been a fantastic test case for this issue of COVID-19, but unfortunately, the employee filed out of time, and the way the Fair Work Commission looks at these things generally is that if you don't file on the 21 days, if you file on the 22nd day, it's not going to be accepted. There's very, very few matters that are now accepted out of time. The bad old days of the 2000s, under the old Workplace Relations Act and the relevant state Industrial Relations Commission, you could file out of time and come up with any BS excuse you want to basically commence your unfair dismissal claim. But ultimately now we see the Commission having a very strict position on those timeframes. But what the Deputy President Asbury said in this particular case, in dismissing the case on procedural grounds, was that both sides of the argument were at least equally arguable. So I think what they're signalling there is that an employer who takes the position that they require an employee to vaccinate will have a decent argument at the very least in the Commission. And you could even take the position that a flu vaccination is theoretically a lower level vaccination when you compare it to COVID. So really, you look at COVID now, you could make the argument as an employer that I'm protecting my employees more with a COVID vaccination and their customers and our other employees than I would be with a flu vax in 2020. And the reason I make that comparison is because if the case was equally arguable based on this set of facts, I think it may be even more arguable on that set of facts. And we will see one this year. There will be a case this year, mark my words, where someone is dismissed for not taking a COVID vaccination. It'll be this year or next year, depending on when the rollout happens, of course. And there will be lots of different reasons put for why employees are not taking the vaccination, whether it's medical, whether it's allergies, whether it's religious reasons. It could even be political reasons. People may even take the view that politically I'm opposed to this, broad vaccination mantra, and that I'm not going to comply with it. So it'll be very interesting to see how all this plays out. I think just the common sense position for now is to just follow the government guidelines, probably nothing more than that. And for those who want to be creative beyond that, well, I guess you probably do so at your own risk to an extent. So yeah, obviously we can't ignore that there has been in some countries some adverse effects or reactions to the vaccination. So again, that has to be also considered in all this. So that is a bit about vaccinations, something to think about for the group, again, and any dealings you might have with clients on this front. The other thing I was going to cover was the end of JobKeeper and restructuring. So obviously it concluded on the 28th of March. I guess this is very much a case of now with the government welfare coming off, we are going to see the businesses that have been swimming naked, so to speak. We'll see how they survive in this post-JobKeeper environment. There may be a number of workplaces that still can't operate at full capacity, and that's going to force businesses to either restructure and make redundancies or to formalise revised arrangements going forward with their employees on new employment contracts. So there's really those couple of choices. For the ones that haven't come back to normal, it's restructure or agree on new arrangements. So it's going to be look at a highly charged political environment. The Fair Work Commission will probably be looking at some unfair dismissals, and we've got a redundancy webinar that you're more than welcome to have a look at on the website, which goes through this in great amount of detail. I'll cover the very basics of redundancy in my next slide. And just for those who've never encountered a redundancy before and think that redundancy can just simply be a one-horse meeting or a one meeting termination, I would certainly advise the group against any of that thinking or against any of that logic. Section 389 of the Fair Work Act requires there is a consultation meeting or that there's consultation prior to termination, and it's very clear that consultation of just telling someone what the decision is not good enough, and that will ultimately fail. So very quickly, and I'm conscious of the time that the group has here, but basically the first step that we always advise to clients is to have an initial consultation meeting. That's where we tell a person who may be made redundant that there is that we're restructuring and that your current position will be affected. It talks about the business case for the restructure and then puts forward any alternative jobs that the business may have as a result of the restructure. So we also recommend a letter that follows that initial meeting. So think of this initial meeting as kind of day one, initial meeting, initial letter to follow, confirming the information about the restructure. We then would recommend what we call a consultation period of 7 days. And during that time, the business is considering, well, what other alternative options might I have rather than making people redundant? The employee might be considering, well, what options are currently on the table for me to stay employed and how do I feel about those options? And depending upon what the options are, they might be exactly like for like, they might be quite different. Some might trigger redundancy, some might not, if they're accepted or declined. So we would recommend a client observe at least a period of 7 days to allow this consultation to occur. If there's no other interviews or processes that need to happen, then we move to a second and or final meeting, which confirms that the person potentially is made redundant, that there's no other alternative roles other than the ones that were already identified, and basically confirms the decision. And then following that second meeting, we'd recommend the second letter be sent confirming those outcomes and confirming anything else around whether the business is offering any outplacement, any counselling services or anything like that. So I want just the group to take away from this that is what I'd recommend what we'd recommend is a very basic and standard procedure for redundancy. Doing anything less than that or doing redundancies in one meeting it's really just asking for trouble. You're going to inevitably fail in consultation, and then you may as well just turn up to the commission with the checkbook open, because ultimately if you're not consulting, you're failing in 389, then it doesn't matter how good your business reason is. If you fail procedurally, there will be some element of compensation one way or another, and it's just a question of how much of that it's going to be. So we recommend that, again, you follow at least this sort of process when you're conducting a redundancy. And the reason we talk about this at this particular point in time is because ultimately JobKeeper's just finished. There are businesses now who are legitimately coming to this crossroad where they're really looking at these things as a viable method of continuing their businesses in a different way. So so that's a bit about redundancy. I've got a few slides to go, so I think it's just one or two left. So we've spoken a bit about tonight about businesses getting their workplace relations affairs in order. We think that businesses, regardless of whether this is through someone like us or someone else, that a workplace relations review is a great start. And look at just looking at your structures. What sort of structures need to be implemented to support your workplace relations function, HR function in your business? The typical things we'd cover in a workplace relations review would be these things. It would be things like working out what awards apply, what classification do each of the employees have, what are the minimum rates that apply to each of those employees under the award and under the classification level. So that's the first thing we do for a whole list of however many employees the business has. We then made recommendations around, okay, with that in mind, what sort of salary, wages, overtime, or other payment structures should the business have? And then that feeds into the contract work. So that feeds into the contract structures work. And typically when we provide contracts to a client, we'll provide numerous different templates. It could be 5, 6, 10 in some cases. Different arrangements for different award coverage, different classifications, different employment status, and so on. The other part we generally look at is the workplace policies, because we find that with workplace policies, what a lot of businesses do wrong, they write these policies that ultimately create unnecessary obligations on the business. And we say to business, well, Fair Work Act is hard enough as it is. Why would you want to create additional policy obligations about this business will do this business will do that in your policies when some of those things are completely unnecessary? The policy should be focused on meeting compliance standards, creating expectations of your employees around performance, and creating expectations of your employees around behaviour and conduct. What it should not be, policy should not be motherhood statements about what a business is going to do and all the extra things that the business is going to do. So those are things that I would say at the very least to avoid, and your policy should have a very clear and defined focus in mind in creating those three things that I just covered. So yeah, a good review should cover also provision of new contracts, provision of policies, having bonus and incentive schemes that are separate from the contract. The worst thing that businesses can do is crystallize bonuses and incentive inside the contract, because then you need agreement to change those arrangements. What you are better off doing is having bonuses and incentives that sit in a separate bonus scheme so that those schemes can be changed by the business without necessarily seeking agreement. So again, nothing wrong with having a loose reference in your contracts to the existence of a scheme, but the scheme itself should sit outside the contract in order for the business to have flexibility in the future. And the common example I always come back to is that you can have a product where you're selling $500,000 worth and making 10% margin, and then you come across a new product where you're going to sell twice as much but at half the margin. And again, that's where, particularly in those sales-based roles, you may need flexibility around these sorts of things in your bonus schemes, because you might write a bonus scheme at one particular point in time, and that might not be fit for purpose in 1, 2, 3, 4 years. So look, those are the general things that we provide in the workplace relations review. We can do things like contract disagreements and so on. And look, post the review, typically we would, if a business wants day-to-day workplace relations support beyond the review, we also have arrangements for those things to occur. So as I said, I'm not trying to sell anything here. I'm just trying to really say that, look, a good review and a business who understands its workplace relations structures will be at least understanding the things that are in that list in the manner that I've described them. So if the organisations that you're working with are not doing those things, then it might be time to start thinking about doing those things, particularly in light of the legislative changes that we've covered tonight and some of the external factors that we've also addressed tonight. So I'm basically at the end of tonight's presentation. So the last couple of takeaways is that, look, we will offer any business a free discussion around their WR affairs to give them some high-level thoughts on what they could be doing better, and any of our consultants can facilitate that. We more generally can facilitate advice and support on any day-to-day workplace relations issues, whether that's managing staff, dealing with policies, disciplining people, terminating people, conducting redundancies, advice on entitlements, and so on. And look, for those who aren't already one of our associate members, we'd recommend that you consider, it's at no charge. You just, on our website, we have an associate member feature that's there. It's just got to check the address. It's www.ondemandhr.com.au/associate. And all that basically is that with any accountants, if you have a question, call us anytime. We'll answer it free of charge. And if you basically want to keep in touch with the webinars we run, typically run one a month on anything from, I think last month we covered, what did we cover last month, Andrew? We covered the floods last month. We're planning on covering next month a sort of a snap of the labour market. We've covered also things like the end of JobKeeper Restructuring and redundancy. So we try and find a topical issue. We won't necessarily do one every month, but it's on average about once a month. Whenever we feel that there's an important topic that we need to bring to the attention of either our clients or associate members, particularly in the accounting fields, because that's where we've developed a lot of great relationships over the years, and where businesses, clients of ours have come from. So we find that those relationships are very valuable. So please, if you've got any questions post tonight, feel free to contact us anytime. Keep in touch with us, via the associate membership. And as I said, give us a call on any questions. Happy to answer them.